Welcome, fellow learners, to another deep dive where we take a stack of sources, articles, and research and really try to extract the most important nuggets of knowledge and insight for you.
Think of us as your guides, helping you navigate these, well, often complex topics, find those surprising facts, and just get well informed without feeling, totally overwhelmed.
And today we are embarking on what looks like a fascinating journey into the European system for the protection of human rights. We've got some incredibly valuable source material provided here, specifically for educational purposes.
Yes, and we really want to acknowledge the University of London for making these important documents available to students. And this deep dive is brought to you by Sinorbit Academy, Sri Lanka.
That's right. And for all of you getting ready for your exams, we absolutely wish you the very best of luck.
We really do. We're going to try and explore the history, the key players, the central challenges.
And really hone in on the key concepts, the cases, the facts that will be most helpful. We'll definitely touch on these important points, probably multiple times as we go, just naturally, to help them really stick for your exam prep.
Absolutely. And, just to set the scene for all of this, it's so vital to remember the context. Where did this modern European human rights system even come from?
Right.
We're talking about the immediate aftermath of the Second World War. Europe was, well, it was in ruins,
Yeah.
facing this huge task of rebuilding, not just physically and economically.
But also rebuilding democracy
Yeah,
itself and a sense of shared values, right?
exactly. Rebuilding that ethical foundation.
Okay, so let's start unpacking this idea of human rights systems. Globally, we have these universal systems, like, the UN system. But Europe and other regions, too, they have their own regional systems. Why? Why this kind of layering?
Yeah, it's a great question. It really boils down to the dynamics of international cooperation.
Yeah.
I mean, think about it. At the universal level, you're trying to get almost 200 states
Wow. Yeah.
with incredibly diverse politics, economies, cultures, legal traditions, all to agree on detailed human rights standards, and maybe even more importantly, accountability mechanisms.
That sounds difficult.
It is. Reaching that agreement globally can be incredibly slow. Often, the standards get watered down because some states are just reluctant to accept strong outside scrutiny. And, geopolitical hurdles like the Cold War back then just made global consensus even harder.
Right. So the more states involved, the more potential roadblocks.
Precisely. Regional systems, though, they usually involve states that are geographically closer. They often share more common ground, maybe similar democratic traditions, market economies, perhaps a shared legal heritage.
Okay.
And that shared context just makes it much more likely they can agree on more detailed standards or even stronger enforcement mechanisms, things they probably wouldn't accept at the big.
Or recognize regional organizations, maybe initially for other things like security.
Yes, that's right.
But then the UN became keen for groups of like-minded states to develop their own protections, especially when the global efforts after the Universal Declaration of Human Rights started hitting those political walls.
Exactly. And that dynamic leads directly to what you see in Europe.
Mhm.
These layers of treaties, often dealing with the very same issues. You can have universal treaties and regional treaties covering the same ground.
And even within those layers, general treaties covering lots of rights and specific ones focusing on just one issue.
Perfect example. Let's use the prohibition of torture, like the source does. It really shows this stacking effect well.
Okay, let's do it. Torture.
So at the universal level, the UN system, right, you've got the ICCPR, the International Covenant on Civil and Political Rights. That's a big general treaty, covers lots of civil and political rights, including the prohibition of torture.
Got it. Universal general.
Then, still universal, still UN, you have a treaty specifically on torture. The UN Convention Against Torture, usually called UN-CATAT. This one goes into much more detailed obligations to prevent torture, punish it, provide remedies for victims, all that.
Okay, universal, specific.
Now let's shift to the regional level in Europe, specifically under the Council of Europe. The main general treaty here is the European Convention on Human Rights, the ECHR, signed way back in 1950. This regional treaty also prohibits torture, among many other rights.
Regional general. So the ECHR.
Right. And just like the UN has its specific torture convention, Europe has one too. The European Convention for the Prevention of Torture, signed in 1987, regional specific.
Wow. So let me get this straight. A state that's party to all four of those ICCPR, UN-CAT, ECHR, and the European Torture Convention is bound by four different legal sources, all saying don't torture.
Exactly. 4 distinct treaty sources just on that one issue. It really highlights the complexity.
That is quite a stack.
It is. And the sources are really clear on this point. Legally speaking, regional treaties are neither superior nor inferior to UN treaties.
Hmm.
Same goes for specific versus general treaties. States just have to uphold all their commitments. They've signed up to them.
Does this layering, does it ever cause issues, conflicts between the rules?
Oh, it absolutely can. I mean,
Okay.
with something like torture, the core prohibition is so widely agreed upon that conflict there is less likely. But in other areas, where treaties might differ on, say, the scope of a right or what limitations are acceptable, yes, you can get conflicts.
Okay.
And figuring out how to navigate those layers and potential conflicts is, well, it's a really crucial underlying theme when you're studying this whole subject.
That makes sense. Even within a region, states have different legal traditions, different policy priorities, and maybe this layering reflects a bit of that idea of cultural relativism, regional systems, highlighting shared values that might have slightly different nuances than a global agreement.
That's a good way to put it. States just have to find a way to manage all these overlapping demands.
Okay, so we've got the big picture, universal versus regional. Now let's really focus our deep dive on Europe itself. The source material points to three main European organizations involved in human rights.
That's right. Those are the Council of Europe, the European Union, and the Organization for Security and Cooperation in Europe, the OSCE.
Let's start with the OSCE. Our sources suggest we don't need to spend too much time on the OSCE for this specific deep dive, right?
Right. While the OSCE definitely addresses human rights, it's not really its main gig. It came about in the 70s during the Cold War, mostly focused on security, conflict prevention, things like that, across a really wide area.
Yeah.
Human rights is just one piece of its work, but not the central mission.
Okay.
So for our purposes, focusing on the core human rights system in Europe, it's just less central than the other two.
Got it. So that leaves the European Union and the Council of Europe. Now, lots of people know the European Union, the EU, mainly as this big political and economic project.
And that's really key to understanding its human rights story. The EU grew out of this desire for economic cooperation after World War II, initially focusing heavily on building a common market. Free movement of goods, capital, services, people. Human rights weren't its explicit founding purpose.
Which is a huge contrast with the Council of Europe.
Oh, absolutely. A fundamental difference right from the start in their origin and their mandate. But human rights became more and more important for the EU over time.
Why was that?
Well, largely for political legitimacy. As the Union got deeper, more integrated, it kind of needed a foundation beyond just the economy. Claiming to be a Europe of values became really crucial.
Mm-hmm.
The sources even hint that the UK's Brexit vote, which was partly linked to worries about legitimacy, really highlighted this pressure on the EU to ground itself in shared values like human rights.
And this led to a sort of complicated relationship with the Council of Europe. The sources call it a tussle of sorts.
Yeah, tussle's a good word. It's complex, sometimes competitive. You've got this tension between two different models. The Council of Europe, which is this dedicated human rights organization with its own human rights court,
Right.
versus the EU, this powerful economic and political bloc that's gradually built human rights into its own structure and law. And that interplay, sometimes they work together, sometimes it's tense, that's all part of the story of human rights in Europe.
But among these three organizations, the sources are super clear. The Council of Europe is the preeminent human rights actor in Europe.
That's right. Its creation in 1949 was specifically about human rights as its core mission, totally unlike the EU's initial economic focus. The Council of Europe is widely seen, and our material backs this up, as probably the most successful human rights organization globally.
That's really high praise.
It is, but it's definitely tempered by the fact that, as the sources note, this successful system is currently under some serious pressure.
Mm-hmm.
And looking at these organizations historically, like we are, it just shows that human rights law and how we enforce it, it's dynamic. It's always evolving, always facing new challenges.
Okay, so the Council of Europe is really our main focus for this deep dive, especially its most famous creation, the IPHR. Let's go back to the very beginning. What was Europe actually like in 1949 when the Council of Europe was created?
Devastated. Just devastated. The war had left countries in ruins, economies shattered, infrastructure destroyed. And beyond just the physical damage, there was this deep, deep scar left on democratic values, on the rule of law. Rebuilding wasn't just about bricks and mortar.
It was about rebuilding trust, political systems, that ethical foundation we talked about.
Exactly. And this is where figures like Winston Churchill come in. The sources quote that famous 1946 speech where he called for a United States of Europe. Churchill's vision was about stopping future wars. He believed Europe had to come together for peace, safety, freedom. And the sources identify two crucial foundations for that lasting peace, lessons learned directly from fascism and the war. One was economic cooperation, which kind of led down the EU path.
Okay.
And the other, critically for us, was mutual respect for democracy, human rights, and the rule of law. These values were seen as essential safeguards against totalitarianism, indivisible.
So the horrors of the war really forced a realization that peace wasn't just politics or economics. It was fundamentally tied to how states treated their own people, whether they upheld these core democratic principles.
Precisely. And then you had the emerging Cold War tensions adding this sense of urgency. United the democratic nations of Western Europe, getting them to commit to these values, became a kind of bulwark against Soviet influence spreading.
This momentum led to concrete action. There was the Hague Conference in May 1948, focused on European unification, and it passed a key resolution calling for a European Convention on Human Rights to be drafted.
And that directly led to the creation of the Council of Europe in 1949, and it was immediately given the job of drafting this convention. Interestingly, the sources mention there was maybe some initial reluctance within the COE itself, perhaps thinking it was too ambitious, too intrusive.
Oh, really?
Yeah, but the value of the convention quickly became clear, and the COE really embraced it as central to building the stability everyone wanted.
And that brings us to the signing of the treaty itself. Let's just underline those key facts again.
Okay, key facts. The European Convention for the Protection of Human Rights was signed in Rome in 1950, just 5 years after the war ended. And it came into force pretty quickly in 1953.
And it guaranteed a core set of rights. Which specific ones do our sources highlight from the start?
It guaranteed key civil and political rights. Things like the right to life, freedom from torture, freedom from arbitrary arrest, the right to a fair trial, the right to privacy, freedom of religion, freedom of expression, and freedom of assembly and association. A solid foundation.
Now, a really significant point right from the beginning was that the ECHR didn't include social and economic rights. Why did they split them?
It's pretty much the same reasons the UN later adopted two separate covenants, the ICCPR for civil political rights and the ICESCR for economic, social, cultural rights. Basically, states had fundamental disagreements about the nature of these different types of rights,
Okay.
particularly whether economic and social rights were really suitable for enforcement by courts, that concept of justiciability. It's arguably easier for a court to rule if your freedom of speech was illegally limited than it is to order a government to provide adequate housing for everyone, which involves huge policy choices, resources.
Right, much more complex implementation. So, to fill that gap for economic and social rights in Europe, the Council of Europe adopted a separate treaty later on.
Exactly. That was the European Social Charter, adopted in 1961.
Yeah.
It specifically covers economic and social rights, acting as the counterpart to the ECHR.
Maybe the most radical thing about the ECHR system when it started was its institutional setup, wasn't it?
Oh, absolutely radical. It
Yeah.
set up an international court, the European Court of Human Rights, the ECTHR, and initially there was also a commission.
Hmm.
But the truly revolutionary part, it was the first international system that allowed individuals to bring complaints and held states accountable before an international court for violating the rights of their own citizens within their own territory.
That sounds like a massive deal for state sovereignty back then.
It was definitely seen that way.
Yeah.
States had reservations.
Yeah.
Initially, they could even choose whether or not to accept the court's jurisdiction. But the court, quite rightly, pushed back against arguments that these violations were just internal affairs. The core principle was clear. The system was built on acknowledging that the state is the primary potential abuser of human rights, and you needed this international backstop.
No, this system has been around over 70 years. The sources really emphasized it's gone through major reforms and is currently under, well, serious pressure. They even call it a victim of its own success.
Yeah, that's a good way to put it. The sheer number of cases flooding the court is a huge issue. But it's not the only pressure. Think about the massive political change and expansion in Europe.
Right, the end of the Cold War.
Exactly. That brought in loads of new member states from Central and Eastern Europe. Countries like Russia, Ukraine, Turkey.
Countries with very different histories, different levels of economic development, different existing human rights challenges compared to that initial small group of Western European democracies.
Totally different context. The system suddenly had to deal with endemic human rights problems, violations from previous regimes, and increasingly challenges from the rise of more authoritarian governments in some member states, think Hungary, Poland, who maybe show less commitment to those core Council of Europe values. It fundamentally changed the game for the convention and the court.
And the system itself had to adapt. The sources talk about the court and states gaining confidence in the system and the need for mutual trust.
Yeah, that mutual trust is absolutely essential for international courts to work well and get compliance. And procedurally, the original system with the commission, filtering cases before they might go to the Committee of Ministers or the court, just got completely overwhelmed and inefficient as the number of cases exploded.
Which led to a major overhaul to streamline things. Let's highlight that key change again.
Okay, repeat this key fact. Protocol 11, which came into force in 1998, made fundamental changes. It abolished the commission. This meant individuals could bring their applications directly to the court. The Committee of Ministers kept its role in supervising judgments, but abolishing the commission really enhanced the court's judicial power significantly.
But even that massive change wasn't enough to handle the workload. The source mentions ongoing pressure and more protocols aimed at efficiency, like protocols 14, 15, and 16.
It's a constant struggle, really, trying to keep the system working under the sheer weight of applications.
Let's touch on one more really interesting point about the origins. The preamble to the convention talks about a shared European political inheritance. What does the source suggest that actually refers to, especially given Europe's, pretty turbulent history?
It's easy to read that and think of this long, unbroken line of democracy and human rights going back to ancient Greece or something. But then you look in the 20th century alone, the world wars, the Holocaust, fascism, communism. It's hard to find a time when those values were consistently upheld across the whole continent.
So the source suggests the preamble isn't just stating a historical fact, it's doing something else.
It argues it's more like an inculcation of values. It's a deliberate act of reminding Europe what it should stand for, a call to recover and commit to these values precisely because they've been so brutally violated. It's aspirational, kind of rooting the future in a specific interpretation of the past.
Like Churchill's warning back in 46 that the dark days could come back if nations didn't unite around these core principles. The convention is basically that commitment written down.
Exactly. It's a dynamic document born out of terrible trauma, looking to prevent it happening again through law and shared commitment.
Now let's pivot slightly and look at the European Union's role in human rights. We said it's distinct from the Council of Europe, different origins, but its human rights side has grown a lot. Let's start with the basic EU treaties.
Okay, repeat those key facts. The modern European Union was formally founded in 1992 by the Treaty on European Union, TEU. That's the Maastricht Treaty. This union was built on the earlier European Economic Community set up by the Treaty of Rome in 1957. And the Treaty of Rome, after lots of changes, is now called the Treaty on the Functioning of the European Union, TFEU.
And it's absolutely critical, we need to keep stressing this, that the ECHR treaties are a completely different source of law from these EU treaties like the TEU and TFEU, two separate organizations, Council of Europe and European Union.
Yes, that distinction is fundamental, even though both legal systems contribute to the overall rights protection picture in Europe.
So how does the source define the EU today, in simple terms?
Well, at its core, it's described as a common economic market among its, 27 member states, mostly Western European democracies, with market economies.
But it's more than just the market.
No, definitely not. Linked to that market is this experiment in social democracy that involves a lot of regulation and a commitment to social, economic, and welfare rights, all aimed at making the internal market work smoothly and making the EU competitive as a big global trade bloc.
The TFEU provides the framework for this market based on its core idea, the four freedoms. Let's repeat those key concepts.
Okay, the four freedoms are the bedrock: free movement of goods, free movement of labor or workers, free movement of capital, and free movement of services across member state borders.
And the sources point out specific rights within the TFU itself that look quite a bit like human rights we see elsewhere.
Yeah, for instance, Articles 18 to 25, backed up by Article 45, give EU citizens the right to move and live freely within the member states. That's a kind of freedom of movement, although specific to the EU context. And Article 141 requires equal pay for equal work between men and women that clearly reflects the broader human rights principle of non-discrimination.
What about the main institutions of the EU? Let's list those again quickly.
Repeat the key institutions. You have the European Commission, that's the executive, proposes laws. The Council of the European Union represents national governments, coordinates policies. The European Parliament directly elected, gives democratic input, legislative role, and the Court of Justice of the European Union, the CJEU, that's the judicial body, interprets and applies EU treaties.
And again, let's be absolutely crystal clear about the distinction between the courts.
Yes, repeat this crucial point. Do not confuse the CJEU with the ECTHR. The CJEU is the EU's court dealing with EU law. The ECTHR is the Council of Europe's court dealing with the ECHR. Two separate courts, two separate legal systems.
Okay. Now, one of the most distinctive things about EU law is how different it is from regular international law. This comes from a really famous CJEU case.
Repeat the case name. Costa v. ENEL from 1964. This case is absolutely fundamental if you want to understand the EU legal order.
And what was the key takeaway from Costa?
The court basically declared that the EU had created its own legal system. And crucially, this system, when the treaty came into force, became an integral part of the legal system of the member states, and national courts were bound to apply it. This wasn't just another treaty. It involved a limitation of the sovereignty or a transfer of powers from the states to the community, creating law that directly bound both states and their citizens.
Now, at first glance, that might sound a bit like international law that needs to be brought into domestic law, like how the UK used the European Communities Act 1972 before Brexit.
True, there are similarities, but the EU system went much further. The CJEU developed these ideas of direct effect, meaning some EU laws applied directly without needing national laws, and critically, the supremacy of EU law.
Supremacy. And the sources illustrate this with that famous series of UK cases.
Repeat the case name. Ex parte factortem. In those cases, the CJEU ultimately required UK courts to effectively disapply a UK Act of Parliament because it conflicted with EU law.
Wow.
That's pretty extraordinary from a traditional legal perspective. A national law passed by a sovereign parliament being set aside by a court because of an international obligation.
Though the source does point out that factortem itself wasn't really about conventional human rights issues.
Right, but it raises this really big question. Given the EU's increasing commitment to human rights, does the supremacy of EU law actually make it a potentially very effective protector of those rights within member states? That was a big question in the UK before Brexit, but it's still relevant for the other 27 members.
And the EU's commitment to human rights has become much more explicit over time.
Yes, definitely. It's legally required now to promote democracy, rule of law, and human rights, both inside the EU and in its dealings with other countries. Repeat this key concept. The EU has adopted its own specific human rights document, the EU Charter of Fundamental Rights.
And what's the status of that EU charter? Is it binding?
Yes, it lists a whole range of civil, political, economic, and social rights and principles. And, crucially, it is legally binding on the EU institutions and on member states, but only when they are acting within the scope of union law.
This brings us back to that tricky issue you mentioned, balancing those EU economic freedoms against human rights. The sources call it a difficult and problematic issue.
It really is. The potential conflict comes up because a core EU freedom like free movement of goods or services could potentially clash with someone's human right, like freedom of expression or association within a member state. And because of that supremacy principle, there's a risk that EU freedom could end up overriding the human right as applied in national law.
Has the CJEU ever actually said, okay, economic freedom wins over this human right?
Well, the sources note the CJEU hasn't explicitly said it's overriding a human right like that. But critics argue that in some cases, the way the court has balanced these competing interests has effectively prioritized the economic freedoms over the individual rights, leaving the balance feeling a bit off.
And partly to deal with these concerns, and also just for legitimacy being this Europe of values, the EU has actually made a legal commitment to join the ECHR itself, hasn't it?
Yes, that's a hugely significant step. The EU is an organization wanting to join a treaty originally designed just for states. But the sources are quick to point out that even though the commitment is there, actually doing it has run into massive logistical and political problems. It's proven much harder than anyone thought.
What kind of obstacles are we talking about?
Well, there are complex technical issues, like how exactly does an international organization like the EU fit into the ECHR system, which is built around states? But there are also big political hurdles. The sources mentioned the views of some Council of Europe members like Russia before it was expelled, who just held really stubborn positions and didn't seem to engage in good faith with the EU or the COE on this.
So even though Protocol 14 of the ECHR technically opened the door for the EU to join...
Yeah, repeat this key fact. Protocol 14 of the ECHR specifically amended the convention to allow the EU to accede. That protocol is in force, but getting the necessary political agreement and sorting out all the technical details just hasn't happened yet. Remember, the ECHR was originally only open to states.
Why is accession seen as so important, symbolically and practically?
Symbolically, it's huge, because it would be an express recognition that EU law is not supreme when it comes to the ECHR. Practically, it would mean that CJEU decisions dealing with rights that are also in the ECHR could effectively be reviewed indirectly by the ECTHR. This would finally resolve the uncertainty about which set of rules takes precedence in this specific relationship. The ECHR would basically become the minimum human rights standard for EU law itself.
No, while the EU is trying to align with the ECHR standard, it also has some unique powers that the Council of Europe doesn't have, particularly under Articles 2 and 7 of the TEU.
Right. Repeat that key article. Article 2, TEU. This is like the heart of the EU's value system. It states the Union is founded on values like respect for human dignity, freedom, democracy, equality, the rule of law, and respect for human rights, including minority rights. It also lists societal values: pluralism, non-discrimination, tolerance, justice, solidarity, equality between women and men. It's a really fundamental statement of what the EU stands for.
And Article 7 provides a procedure related to those values, a way to enforce them.
Yes, repeat that key article. Article
Yeah.
7, TEU. This sets out a procedure to deal with breaches of the article to values. It allows the Council of the EU to determine if there's a clear risk of a serious breach of these values by a member state. That requires a 4/5 majority vote.
And there's an even more serious finding possible.
Yes, the European Council, acting by unanimity, can determine the existence of a serious and persistent breach of those values.
And if a serious breach is found, what happens? What are the consequences?
Then the Council, acting by a qualified majority, can actually suspend certain rights of that member state, including, most significantly, their voting rights in the Council. That's a pretty big political threat.
It certainly sounds like it. Exclusion from decision-making.
It is. And beyond voting rights, it can lead to other pressures, like potentially withholding EU funds, which can really hit hard for states relying on EU money. But the sources do note that actually activating and pushing this mechanism through, especially against powerful member states, has proved politically very difficult. Even with concerns raised about rule of law issues in places like Hungary and Poland, where procedures have been started and are ongoing, it's a slow and politically charged process.
So, while the Article 7 mechanism exists as this distinct political tool for upholding core values, different from the ECTHR's judicial focus, its actual effectiveness can be limited by the political realities within the EU itself.
It's another layer of complexity, isn't it? That constant interplay between law and politics in European human rights protection.
Okay, let's move beyond the ECHR for a moment, but stay within the Council of Europe. It's developed a whole range of other human rights treaties too, hasn't it? Stemming from that original commitment to unity and common values.
Yeah, quite a few. An important one we mentioned when talking about treaty layers is the European Convention for the Prevention of Torture and Inhuman or Degrading Treatment or Punishment. That was adopted in 1987.
And this adds to Article 3 of the ECHR, the torture prohibition.
Right. Its main contribution is creating a preventative mechanism. It established the European Committee for the Prevention of Torture, the CPT. And the CPT has this unique power. It can conduct visits to places of detention prisons, police stations, psychiatric hospitals in state parties to monitor how people deprived of their liberty are actually treated.
So they go in and see for themselves.
Exactly. And after a visit, the CPT produces a confidential report for the state with its findings and recommendations for improvement.
So the CPT works to prevent torture and ill treatment before it happens or catches it early, whereas the ECTHR deals with complaints after an alleged violation.
Precisely. Two different but complementary approaches tackling the same serious problem.
Another really important regional treaty from the Council of Europe is the European Social Charter.
Yes, repeat that key treaty name. The European Social Charter, or ESC. As we discussed, this is the counterpart to the ECHR, specifically covering economic and social rights.
And it's evolved over time, different versions.
It has. The original charter was from 1961. Then an additional protocol in 1988 added some new rights. And most significantly, the revised European Social Charter was adopted in 1996. That one substantially revised, updated, and added rights. The sources point out that different states are party to different versions, some only the original, some the original plus the 88 protocol, most now to the revised charter. And some COE members haven't ratified any version at all.
How does the ESC system actually work To make sure states complied has two different supervision mechanisms, right?
That's right. The first and the oldest one is the reporting procedure. That's been around since 1961, and it's mandatory for all states party to the charter.
How does that work? States write reports.
Yeah, states submit these detailed reports on how they're implementing the rights they've accepted. It happens on a cycle currently, every 2 years for core rights, every 4 years for non-core rights. These state reports, along with comments from national employer and worker groups and NGOs, are then reviewed by the European Committee of Social Rights, the ECSR.
The ECSR, those are the independent experts again.
Correct. The ECSR is a body of independent experts. They look at the reports from a legal perspective, assessing if the state's law and practice actually comply with the charter. Their findings are published as conclusions.
Okay, so the experts give their view. Then what?
Then these conclusions go to the governmental committee of the charter. Now, this committee is made up of representatives from the state parties. They prepare a report, which then goes to the Committee of Ministers of the Council of Europe.
Ah, so the Committee of Ministers, the political body representing all the member state governments, is at the end of this chain too.
Yes. And based on the governmental committee's report and the ECSR's conclusions, the Committee of Ministers may its discretionary address non-legally binding necessary recommendations to the state party, asking them to change their law or practice. This needs a two-thirds majority vote.
And the role of the ECSR, the experts in all this.
Repeat this key concept. The ECSR is the only body competent to give an authoritative interpretation of the charter. Even though their findings get politically reviews later on, their interpretations build up the jurisprudence of the charter.
What's seen as the main weakness of this reporting system?
The sources are pretty blunt. They highlight the fundamental and continuing weakness is its lack of real independence from the state's parties themselves. Because the process involves review by a governmental committee and ends with the political committee of ministers having discretion, it's not a purely legal or judicial process like the ECHR.
So it lacks teeth sometimes.
It can. While it has led to some positive changes in national law over the years, states have also just ignored findings of noncompliance without facing serious consequences.
Okay, that's the reporting system. What's the second mechanism that was introduced later?
Yes, the collective complaint system. This was established by an optional protocol in 1995. Optional meaning states have to specifically sign up to this protocol to be bound by it.
And the goal of this system was?
The preamble to the protocol says the aim was to improve the effective enforcement of the social rights guaranteed by the Charter, and also to strengthen the participation of management and labor and of non-governmental organizations, basically make it more effective.
So, unlike the ECHR, individuals can't bring complaints under this system.
Correct. Repeat this key concept. It is a collective complaint system, not an individual one. Complaints can only be lodged by specific types of organizations listed in the protocol, mainly international employers and workers' organizations, and certain international NGOs that have consultative status with the Council of Europe and are on a special list.
How does that process work then? An organization complains.
An eligible organization lodges a complaint with the ECSR, the Experts Committee. The ECSR decides if the complaint is admissible. If it is, they investigate and draw up a report on the merits, deciding whether the state is complying or not. This report, with the ECSR's finding, then goes to the Committee of Ministers.
And if the ECSR finds the state isn't complying?
Then the Committee of Ministers shall adopt a recommendation to the defendant state, again needing a two-thirds majority.
So it's a shall adopt this time, not may adopt like in the reporting system. A bit stronger.
Slightly stronger language, yes, but the outcome is still a non-legally binding recommendation, not a court judgment finding a violation like you get from the ECTHR. The sources note this system has generated a growing number of complaints and useful interpretations, but the numbers are still tiny compared to the ECTHR's caseload, partly because it's optional and not all states have accepted it.
Let's look quickly at some specific features of the rights in the ESC itself.
Okay, one really unique thing compared to most human rights treaties is that the Charter allows states parties not to accept all the rights it contains. They have to accept a certain core minimum, but they can kind of pick and choose some others.
Why did they allow that?
It was a pragmatic compromise back in 1961. The Council of Europe members then had quite different levels of social and economic development, so requiring everyone to accept everything immediately just wasn't realistic.
And you mentioned a big difference from the UN's ICSCR earlier about how the rights take effect.
Yes, unlike the ICSCR, which talks a lot about progressive realization, meaning states implement rights gradually over time, as resources allow. The rights in the European Social Charter are generally considered not progressive in nature. They are mostly seen as being of immediate effect. That's a significant distinction.
Immediate effect, but maybe not always clearly written.
Well, some provisions, especially those dealing with broad social policy goals, are drafted in quite vague, sort of aspirational language. And that feeds into the argument some people make that economic and social rights aren't really justiciable, suitable for courts to enforce.
But not all of them.
No, not at all. Many other provisions, especially those about employment rights, working hours, fair pay, trade union rights, are actually drafted with enough precision that they could be judicially enforced in national courts.
And finally, who actually benefits from these ESC rights? Is it everyone?
No, and this is another key difference from the ECHR. The rights in the ESC apply only to nationals of the state party and to lawfully resident or working nationals of other states' party to the charter. It does not apply to everyone within the state's jurisdiction, regardless of nationality, like the ECHR does.
Okay, so that gives us a really good picture of the European Social Charter. It's the counterpart to the ECHR for economic and social rights, but with a very different, arguably weaker enforcement system and some unique features about which rights states accept and who benefits.
It's a really important piece of the European human rights puzzle, even if it's less well known than the ECHR.
Right. Now, let's dive back into the European Convention on Human Rights itself. The sources called it the jewel, but also noted it's under serious stress. Let's get deeper into the specific rights laid out in Section 1.
Okay, Section I contains the catalog of rights. Article 1 really sets the stage. It says, states undertake to secure to everyone within their jurisdiction the rights defined in the convention. And actually, that phrase within their jurisdiction has become a whole area of a case law itself. Complex questions about whether the convention applies outside a state's own territory, like during military operations abroad.
Okay. Then Article 2, the right to life.
This is a foundational right. It's defined more extensively than in the UDHR, and crucially, it's considered an absolute right in almost all circumstances. Repeat this. No derogation is possible from Article 2 under Article 15.2, except for deaths resulting from lawful acts of war. It also imposes a positive duty on the state to take reasonable steps to protect life.
But it does list some specific situations where using force, even lethal force, might not be a violation.
Yes, but these are very strictly defined exceptions. They include carrying out a death sentence imposed by a court, though remember Protocol 6 and later Protocol 13 have largely abolished the death penalty in Europe now. Also, force used when absolutely necessary in self-defense or defending others from unlawful violence, force used to make a lawful arrest or prevent escape, or force used lawfully to quell a riot or insurrection. The absolute key here is that the force used must be strictly proportionate to the legitimate aim being pursued.
Next, Article 3, the prohibition of torture, inhuman or degrading treatment or punishment.
Repeat this critical point. Article 3 is also absolute. No derogation is possible under Article 15.2, ever, not even in a time of war or public emergency.
How did the court first define torture? Was there a distinction?
Yes. In an early, very important case, Ireland v. UK, from 1980, which dealt with interrogation techniques used in Northern Ireland, the court defined torture as deliberate, inhuman treatment causing very serious and cruel suffering. It placed torture on a higher level of severity than inhuman or degrading treatment. Interestingly, in that specific case, the 5 techniques used were found by the court to be inhuman and degrading treatment, but they didn't reach the threshold of torture as defined then.
But the court's understanding of torture has evolved since then.
It has, influenced partly by the definition of torture in Article 1 of the UN Torture Convention. The court's later case law, especially in cases involving Turkey and France, did find torture had occurred in situations that might not have met that very high threshold set in Ireland v. UK. So the understanding of what constitutes torture has definitely broadened over time, aligning more closely with the UN standard.
And we mentioned earlier, Article 3 is supplemented by that other convention.
Right, the European Convention for the Prevention of Torture and the work of the CPT, the committee that visits detention centers. That provides a really important preventative layer of protection for Article 3 rights.
Okay. Article 4 prohibits slavery and forced labor.
Paragraph 1 prohibits slavery and servitude, and this part is also absolute no derogation possible under Article 15.2. Paragraph 3 then lists specific things that are not considered forced or compulsory labor under the Convention, things like work required during lawful detention, military service, service required during emergencies, or normal civic obligations like jury duty. The sources say this article hasn't generated a huge amount of case law compared to some others.
Article 5 is the right to liberty and security.
The opening line is positive. Everyone has the right to liberty and security of person. What this means is that arbitrary deprivation of liberty is prohibited. You can't just be locked up without a proper reason and legal basis.
But, like the right to life in Article 2, there are specific listed exceptions where detention is allowed.
Exactly. Paragraph 1 lists these exhaustively. Detention is lawful only in these situations and when it's prescribed by law, meaning it has a clear legal basis that's accessible and foreseeable. The exceptions cover things like lawful detention after being convicted by a court, arrest or detention for not complying with a lawful court order, detention on reasonable suspicion of committing an offense or to prevent one, detention of minors for educational supervision, detention to prevent the spread of infectious diseases or of persons of unsound mind, alcoholics, drug addicts, and lawful arrest or detention to prevent unauthorized entry into the country or during deportation extradition proceedings.
And Article 5 also includes really crucial procedural safeguards if you are detained.
Absolutely vital. You have the right to be informed promptly why you've been arrested and what charges you face, to be brought promptly before a judge or a similar judicial officer, to have a trial within a reasonable time or be released pending trial, to challenge the lawfulness of your detention before a court, habeas corpus, and to get compensation if your Article 5 rights have been violated.
This article sounds like it would generate a lot of cases: criminal detention, immigration detention, psychiatric detention. The SWAF has mentioned an important early case defining what liberty means here.
Yes, repeat the key case. Engel v. the Netherlands, No. 1, from the late 70s. This involved disciplinary measures against soldiers.
And how did the court interpret Article 5.1 in that case?
The court clarified that Article 5.1 is about individual liberty in its classic sense, that is to say, the physical liberty of the person. Repeat this. Article 5 focuses on deprivation of physical liberty and preventing arbitrary detention. Its aim is to stop people being arbitrarily deprived of their physical freedom. In the Engel case, the court found that regular military discipline, while restrictive, didn't usually amount to a deprivation of liberty under Article 5, although detention going beyond normal service life could.
Okay. Now, Article 6. The right to a fair trial. The sources say this is a huge one, maybe generating more cases than almost all the others put together.
It's incredibly broad and fundamental. Article 6.1 applies not only to the determination of criminal charges against you, but also to the determination of your civil rights and obligations. And civil rights and obligations has been interpreted very widely by the court.
So it's not just about criminal courts.
No, far from it. It can apply to administrative tribunals dealing with things like planning permission, professional licenses, Social Security benefits, employment disputes, property disputes, basically.
Yeah.
Anybody whose decision determines a civil right or obligation in the convention sense.
What are the minimum guarantees for a fair hearing under Article 6.1?
You have the right to a hearing by a lawfully constituted, independent, and impartial tribunal established by law. The hearing must be held within a reasonable time, and the hearing and the judgment should generally be public, although there are legitimate exceptions for reasons like public order, national security, protecting the private life of parties, or the interests of juveniles.
And if you're actually charged with a criminal offense, Articles 6.2 and 6.3 give you additional specific minimum rights.
Yes, these are crucial for criminal defendants. They include the presumption of innocence until proven guilty, according to law, the right to be informed promptly of the accusation against you, the right to have adequate time and facilities to prepare your defense, the right to defend yourself in person or through a lawyer of your choosing, and the right to free legal aid if you can't afford it and the interests of justice require it, the right to examine witnesses against you and call witnesses for you, and the right to the free assistance of an interpreter if you don't understand the language used in court.
For the civil rights side of Article 6.1, what's required for it to apply? Does it create rights?
No, this is important. For Article 6 to apply to a civil matter, the applicant needs to show they have an arguable right under domestic law. Repeat this. Article 6.1 does not create new substantive civil rights. It provides procedural guarantees for the determination of rights that already exist or are arguably claimed under national law, as long as that claim is tenable.
So it acts as a constraint on states trying to take things away from the courts.
Exactly. It stops states from just removing civil disputes or decisions affecting rights from the jurisdiction of independent courts or granting immunities that block access to justice. The court has also recognized important implied rights under Article 6, like the fundamental right of access to courts, which can only be restricted in very specific, justified circumstances.
The sources give a helpful five-question structure for analyzing potential Article 6 violations. Can you walk us through that?
Yeah, it's a good way to think about it. First, is the body or proceeding determining a civil right or obligation or a criminal charge? Second, if it's criminal, were the minimum guarantees in 6.2 and 6.3 respected? Third, were any of the express rights in 6.1, like independent tribunal, reasonable time, public hearing, infringed? Fourth, was an implied right, like access to court, infringed? And if so, was the restriction justified, legitimate aim, necessary, proportionate? Fifth, did the applicant validly waive any of their Article 6 rights? Thinking through those steps helps structure the analysis of often complex, fair trial issues.
Okay, Article 7. This embodies a really fundamental principle of criminal law.
Yes, repeat this principle. Article 7 is the principle of no punishment without law. The Latin is nolum crimen, nulla poena sine lege. And like Article 3, it's absolute. No derogation is possible under Article 15 too.
What does that mean in practice for individuals and for the law itself?
Primarily, it prohibits applying criminal law retrospectively to someone's disadvantage. You can't be punished for doing something that wasn't a crime when you did it, or given a harsher penalty than was applicable at the time. More broadly, it means that only the law can define what a crime is and what the penalty is.
And the law has to be clear, right? You have to be able to know what's forbidden.
Absolutely crucial. The source quotes the court in Kokkinakis v. Greece, stating that an offense must be clearly defined in law. Repeat this key concept. The law must be clear enough and accessible enough that an individual can understand, either from the wording itself or from how courts have interpreted it, what actions or omissions will make them criminally liable. Criminal law cannot be stretched or interpreted extensively to an accused person's detriment, for instance, by applying it by analogy to situations it wasn't clearly intended to cover.
Okay, those first few articles, 2, 3, 4, 1, 5, 6, 7, feel like the real bedrock, some absolutely non-negotiable. Now, Articles 8 through 11 are often looked at together because they have a similar structure.
That's right. They all follow a pattern. Paragraph 1 sets out the substantive right, and then Paragraph 2 lays out the grounds on which that right can be limited or restricted by the state. And importantly, unlike Articles 2, 3, 4, and 7, these rights can be derogated from under Article 15 in a public emergency. This suggests they're seen as fundamental, yes, but perhaps not quite as absolutely inviolable as those core non-derogable rights.
So, Article 8, the right to respect for private and family life, home, and correspondence. Very broad.
Very broad indeed. Paragraph 1 defines the scope. Paragraph 2 then says that any interference by public authority with this right is prohibited unless that interference is in accordance with the law and is necessary in a democratic society for achieving one of the listed legitimate aims.
And what are those legitimate aims listed in Article 8 too?
They include things like protecting national security, public safety, the economic well-being of the country, preventing disorder or crime, protecting health or morals, or protecting the rights and freedoms of others. It's quite a wide list.
And the court has also said Article 8 isn't just about not interfering. It can sometimes require states to do something, positive obligations.
Yes, exactly. Well, paragraph 2 is about stopping state interference. The court has recognized that there may, in addition, be positive obligations inherent in effective respect for family life or private life. For example, requiring states to take reasonable steps to protect individuals from harm by others, or to facilitate family reunification in certain circumstances, as mentioned in cases like Kroon v. the Netherlands. Defining the exact scope of these positive obligations can be tricky, though.
How does the court decide if an interference with Article 8 is actually necessary in a democratic society and therefore allowed?
Repeat this key concept. The court carries out a balancing exercise. It has to weigh the individual's right to respect for their private or family life against the broader interests of the community or the state that the interference aims to protect, like public safety or the rights of others. It seeks a fair balance between these competing interests. And in doing this balancing, the state is given a certain amount of discretion, the margin of appreciation.
That margin of appreciation concept, again, let's just quickly reiterate what that means in this context.
Repeat this. The margin of appreciation is the discretion or leeway the IPHR gives to national authorities, governments, parliaments, courts, in deciding how best to implement convention rights and balance them against competing interests within their own specific national context. It acknowledges that national authorities might be better placed initially to judge local needs and conditions and reflects the diversity across Europe. The width of this margin can vary depending on the right involved and whether there's a strong consensus among European states on the issue.
Got it. Okay, Article 9, freedom of thought, conscience, and religion.
The source notes something interesting here. This article didn't generate a huge amount of case law initially, but that has changed enormously in recent years.
Why the big increase in Article 9 cases?
Well, it's increasingly being invoked in all sorts of modern conflicts and disputes, clashes between different religions, or between religious views and secular state policies, or where religious practices intersect or clash with other rights like freedom of expression, non-discrimination, or state rules on things like education or wearing religious symbols.
And like Article 8, it has a paragraph 2 allowing for restrictions.
Yes, exactly the same structure. Interference is only allowed if it's prescribed by law and necessary in a democratic society for specific aims: public safety, protecting public order, health or morals, or protecting the rights and freedoms of others.
Article 10 is the right to freedom of expression. Hugely important.
Absolutely fundamental. It's defined broadly to include the freedom to hold opinions and to receive and impart information and ideas.
And it also has a paragraph 2 with a list of permissible restrictions. Quite a long list this time.
Yes, it is. Interference is subject to formalities, conditions, restrictions, or penalties, as are prescribed by law and are necessary in a democratic society. And the list of legitimate aims is quite extensive and slightly different from Articles 8, 9, and 11. It includes protecting national security, territorial integrity or public safety, preventing disorder or crime, protecting health or morals, protecting the reputation or rights of others, preventing the disclosure of information received in confidence, or maintaining the authority and impartiality of the judiciary.
The court has consistently stressed just how fundamental this right is, hasn't it?
Oh, consistently. In that landmark case, Handyside v. UK from 1976, repeat that key case, Handyside v. UK. The court famously stated that freedom of expression is one of the essential foundations of a democratic society. And it elaborated that this protection applies not just to ideas that are favorably received or seen as inoffensive, but also to those that offend, shock, or disturb the state or any sector of the population.
Wow.
That protection, the court said, is necessary for pluralism, tolerance, and broad-mindedness, which it saw as the very hallmarks of a democratic society.
So incredibly important, fundamental even, but clearly not absolute given that long list of potential restrictions in paragraph 2.
Exactly. The real challenge for the court in Article 10 cases is always balancing the fundamental importance of free speech against those legitimate interests that states are allowed to protect under paragraph 2.
Article 11 covers the linked freedoms of assembly and association.
Right. Freedom of peaceful assembly covers things like protests, marches, demonstrations. Freedom of association includes the right to form and to join trade unions, which is obviously very important. Again, like the others in this group, 8, 9, 10, interference is only allowed if it's prescribed by law and necessary in a democratic society for the sake of national security or public safety, preventing disorder or crime, protecting health or morals, or protecting the rights and freedoms of others.
And there's a specific mention at the end of Article 11, too, about certain groups.
Yes, it explicitly states that lawful restrictions can be placed on the exercise of these rights by members of the armed forces, of the police, or of the administration of the state.
Okay. Article 12 is the right to marry.
This guarantees the right for men and women of marriageable age to marry and to found a family. But crucially, according to the national laws governing the exercise of this right. So states have regulatory power, but their laws shouldn't be arbitrary or effectively destroy the basic right itself.
Article 13 guarantees the right to an effective remedy.
Yeah, this basically means that if you have an arguable claim that your convention rights have been violated by the state, you should have access to some kind of national authority. Not necessarily a court. It could be an administrative body that can actually consider your complaint and provide a remedy if a violation is found.
And Article 14 is the prohibition of discrimination. How does this one work?
Repeat this key concept. Article 14 in the original convention is not a freestanding right. It doesn't prohibit discrimination in general. Instead, it reads a non-discrimination clause into each of the other substantive rights in Articles 2 through 12 and the protocols.
Yeah.
It says the enjoyment of those rights shall be secured without discrimination on any grounds such as sex, race, color, language, religion, political or other opinion, national or social origin, association with a national minority, property, birth, or other status. So it prohibits discrimination only in the enjoyment of other specific convention rights.
But that was expanded later.
Yes. It was supplemented by Protocol 12, which did create a freestanding general prohibition of discrimination regarding any rights set forth in law, not just convention rights.
Yeah.
But That's an optional protocol, so it only applies to states that have specifically ratified it.
We briefly mentioned Article 15, the derogation clause, earlier, just to recap its significance.
Right. Article 15 allows states, in times of public emergency threatening the life of the nation, to temporarily suspend some of their obligations under the convention. But, and this is critical, it explicitly lists rights that cannot be derogated from under any circumstances. Article 2, right to life, except deaths from lawful acts of war. Article 3, prohibition of torture. Article 4.1, prohibition of slavery servitude. And Article 7, no punishment without law. This really underscores their absolute fundamental nature.
Okay. And finally, there's a little group of articles at the end of Section 1, 16, 17, and 18, often read together as general limitations.
Yeah. Article 16 allows states to restrict the political activities of foreigners, aliens. Article 17 is really interesting. It's an anti-abuse clause. Repeat this. It prevents any state, group, or individual from relying on the convention to justify engaging in activities aimed at destroying any of the rights set forth in the convention or limiting them more than the convention allows.
And the sources link this to protecting democracy itself.
Exactly. In an early case, KPD v. FRG, the German Communist Party case, repeat that key case, KPD v. FRG. The commission, it was the commission back then, upheld the ban on the party, reasoning that its aims were incompatible with democracy. And Article 17 prevented the party from using rights like freedom of assembly to undermine the very democratic system the convention was designed to protect. It's basically a safeguard against using human rights to destroy human rights or democracy.
In Article 18, what does that do?
Article 18 isn't an independent right either. You can only invoke it alongside an alleged violation of another substantive right. Its purpose is to stop states using a restriction permitted for one right, say public safety under Article 11, as a pretext for achieving an improper ulterior motive, or for restricting a different right in a way not permitted by the convention.
Okay, that's a really comprehensive tour through the catalog of rights in Section 1 of the IPHR. Gives a solid grasp of the core protections.
It really does. Those are the substantive guarantees the whole system is built on.
Now let's move to Section 2 of the Convention. This is the part that sets up the actual machinery, the court, and how the system operates. And the sources stressed there have been big changes here over time.
Yes, huge changes, mostly driven by that massive increase in workload we talked about. We already mentioned Protocol 11 making big reforms. Then came Protocol 14, which entered into force in 2010. That introduced further measures trying to make the court more efficient, although even then, everyone knew it probably wouldn't completely solve the caseload problem.
Article 19 is simple. It establishes the court itself.
Repeat this key institution, the European Court of Human Rights, the ECTHR. Then subsequent articles deal with how judges are elected, their terms of office, and so on.
And their independence is crucial.
Absolutely. Article 21 is key. It requires judges to serve in their individual capacities. They must be impartial, independent, and not represent the state that nominated them.
How is the court actually organized internally to handle all the cases?
Articles 27 to 30 describe the different formations. The court sits in committees of 3 judges, chambers of 7 judges, and a grand chamber of 17 judges. These different formations have different roles and powers, especially when it comes to deciding early on whether an application is admissible or not.
Article 32 defines the court's jurisdiction, what it has power over.
Right. Article 32.1 says its jurisdiction covers all matters concerning the interpretation and application of the convention and its protocols. And Article 32.2 gives the court the general power to decide on its own jurisdiction if there's a dispute about it. That's pretty standard for international courts.
Article 33 deals with a specific type of case. Interstate cases.
Yes, this allows one state party to the convention to bring a case against another state party, claiming they've violated the convention. The sources note that this hasn't happened very often in the court's history. It's usually reserved for situations involving really serious alleged breaches.
Article 34 is where the system really opens up to individuals, isn't it?
Yes, this is the powerhouse. Repeat this key innovation. Article 34 grants the right of individual application. The court may receive applications from any person, non-governmental organization, or group of individuals who claim to be a victim of a violation of their convention rights by a state party.
That right of individual petition is absolutely central to how the ECHR system works.
It's the cornerstone. Repeat this key concept. The right of individual petition allows ordinary people, NGOs, groups, to directly challenge state actions before an international court. It's incredibly powerful. But this right is subject to very strict admissibility criteria laid out in Article 35.
What are those crucial filters in Article 35? What hurdles does an application have to clear before the court will even look at the substance?
Well, the big one, the first hurdle usually, is the requirement to exhaust domestic remedies. You have to try and get the problem fixed through the courts and legal system within the state, concerned first, before you can go to Strasbourg. The idea is to give the national system the first chance to put things right.
Okay, exhaust domestic remedies. What else?
Article 35(2) lists others.
Yep.
The application can't be anonymous. It can't be substantially the same as a case the court has already dealt with, or that's being looked at by another international body, like a UN committee, unless there's significant new information.
And Protocol 14 added another filter aimed at sort of trivial cases.
Exactly. Article 35, 3b, as amended by Protocol 14, says the court shall declare inadmissible any individual application if it considers that the applicant has not suffered a significant disadvantage.
Why did they add that significant disadvantage rule? What was the thinking there?
It was explicitly put in by Protocol 14 to help deal with the absolutely crushing caseload. The aim was to let the court filter out applications about very minor or technical violations that didn't really cause the applicant any serious harm or prejudice. It frees up the court's very limited time and resources to focus on the more serious human rights issues.
And beyond those specific criteria, the court also has broader powers to reject applications early on.
Yes. Article 35 also allows the court to declare applications inadmissible if they're incompatible with the provisions of the convention, like complaining about something the convention doesn't even cover, or if they're manifestly ill-founded, meaning there's just clearly no arguable case of a violation on the face of it, or if the application is an abuse of the right of individual petition, maybe someone is lying or using the system improperly. And the court also has a wide power under Article 37 to just strike applications out at various stages, for example, if the applicant stops pursuing the case.
Article 36 talks about states being involved in the proceedings.
Right. Once a case gets past admissibility and is being considered by a chamber or the grand chamber, the state party that the complaint is against has the right to submit written comments and take part in any hearings. Other states can also ask to intervene if the case raises important general principles.
Once a case is declared admissible, Article 38 allows the court to investigate further.
Yes, the court can carry out investigations to establish the facts, and the states involved are obliged under the convention to provide all the necessary facilities to help the court do that. And Article 39 puts an obligation on the court at any stage to try and help the parties reach a friendly settlement, basically, an agreement to resolve the case, as long as the terms respect human rights.
And if the court investigates and finds there was a violation, what can it do?
If the court finds a violation of the convention, and if the national law of the state doesn't allow the consequences of that violation to be fully repaired, then Article 41 gives the court the power to award just satisfaction to the injured party. This usually means ordering the state to pay financial compensation for any damages suffered, plus legal costs and expenses.
How do the court's judgments actually become final and binding?
Article 44 explains this. A judgment from a chamber becomes final if neither party asks for the case to be referred to the Grand Chamber within 3 months, or if such a request is made but rejected by the Grand Chamber's panel. Judgments for the Grand Chamber itself are final as soon as they are delivered.
And states are legally required to comply with these final judgments.
Yes, this is the crucial enforcement part. Repeat this fundamental obligation. Article 46 states that the high contracting parties undertake to abide by the final judgment of the court in any case to which they are parties. This creates a binding international legal obligation on the state, not only to provide any remedy ordered for the individual applicant, like paying compensation, but also, if necessary, to take general measures like changing laws or practices to prevent similar violations happening again in the future.
Finally, Article 47 mentions advisory opinions. What are those?
The court can issue these, but only at the request of the Committee of Ministers, and the power is quite limited. Advisory opinions can't be about the actual content or scope of the rights in Section 1, nor can they be about questions the court might have to decide in a normal contentious case. They're meant for more abstract legal questions about interpreting the convention or its protocols.
Okay, so Section 2 really describes the vital machinery of the court itself, its powers, the whole process from lodging a complaint right through to a final binding judgment.
Exactly. It's the engine that makes the IPHR system run, though, as we've seen, an engine that's constantly being tweaked and reformed to try and cope with the demand.
Now, we've mentioned several protocols throughout this discussion. The sources are clear. There are many of these, adding to or amending the original convention text.
Yeah, protocols are basically how the convention system gets updated or expanded over time, We've already talked about Protocol 11 and 14 being really important for institutional reforms and admissibility rules, and Protocol 12 for adding that freestanding non-discrimination right.
Let's just quickly recap some of the other important protocols that actually added new substantive rights to the system.
Okay, repeat this key addition. Protocol 1 was very significant. It added 3 rights. The right to property, Article 1. The right to education concerning parental educational preferences, Article 2. And the right to free elections, Article 3.
Then Protocol 4. Repeat this key addition.
Protocol 4 added several protections related to freedom of movement. Freedom from being imprisoned just for debt, Article 1. The liberty of movement and freedom to choose where you live within a country, Article 2. Freedom from being exiled from your own country, Article 3. And a very important prohibition on the collective or mass expulsion of foreigners, Article 4.
Protocol 6 was a major step. Repeat this key addition.
Yes, Protocol 6 is crucial because it prohibits the death penalty in time of peace, Articles 1 and 2. Later protocols went even further, but this was the first big step.
And Protocol 7. Repeat this key addition.
Protocol 7 added several more procedural rights, mostly related to criminal justice and family law. The right for foreigners lawfully resident not to be expelled without due process, Article 1. A general right to appeal against conviction or sentence in criminal cases, Article 2. A right to compensation for miscarriages of justice, Article 3. The principle of nebis in idem, meaning you can't be prosecuted or punished twice for the same criminal offense, Article 4. And equality of rights and responsibilities between spouses regarding their children, Article 5.
And we mentioned Protocol 12 again, supplementing Article 14's non-discrimination clause.
Right. Protocol 12 prohibits discrimination on any ground regarding any right set forth in law, not just IPHR rights. But remember, it's optional, only applies if a state ratifies it.
These protocols really show that the convention isn't just some static historical document. It has evolved, adding new protections as consensus developed among the member states over the decades.
Exactly. Though it also means the precise set of obligations can vary slightly from state to state, depending on exactly which protocols they've signed up to.
Okay. Now, one of the most celebrated ideas the court uses, the thing that keeps the convention relevant in a constantly changing world, is this concept of it being a CAF.
Repeat this core concept. The court consistently refers to the convention as a living instrument.
A living instrument. What does that actually mean in practice for how the court makes decisions?
It means the rights guaranteed in the convention have to be interpreted in the light of present-day conditions. The court believes the convention needs to evolve, its interpretation needs to evolve to stay effective and relevant. Otherwise, its standards would just become outdated as society changes, as values shift. So this approach allows the court to revisit its own past decisions and adapt its interpretation when there's a clear trend or developing consensus among member states on a particular issue. What might have been considered acceptable treatment or state action decades ago might well be found to be a violation today, precisely because the standard has evolved.
So the court's interpretation isn't frozen in time back in 1950 when it was drafted.
Exactly. It's a dynamic interpretation. It aims to ensure the convention's protections remain meaningful and that its standards generally improve over time, reflecting the developing European consensus on human rights values.
And the sources provide a really fantastic case study to illustrate this whole living instrument idea in action, showing how standards evolved, particularly under Article 8, private and family life, and Article 12, right to marry. This is that fascinating series of cases against the UK involving the legal recognition of transsexual individuals.
Yes, it's a perfect example. Repeat those key articles involved.
Okay.
Article 8, right to respect for private and family life, and Article 12, right to marry. This series of cases really shows a clear progression in the court's thinking, unfolding over nearly 20 years.
The first case mentioned is Rees v. the United Kingdom back in 1986.
Right. In Rees, the applicant was a female-to-male transsexual who wanted legal recognition of his gender after surgery. Specifically, he wanted his birth certificate amended to show him as male. The court found no violation of Article 8. Well, it reasoned that legally recognizing the change and amending the birth register, which was seen as a historical record, involved really complex administrative and social issues. And given the lack of consensus among European states on how to handle this back then, the UK was given wide discretion, that margin of appreciation. The balance under Article 8.2 was seen to tip in favor of the state's interests at that time. The court also found no violation of Article 12, the right to marry, basically saying the traditional concept of marriage under national law was based on biological sex at birth.
But even in that very early case, finding no violation, the court sort of hinted things might change.
Yes. Crucially, even while dismissing the complaint, the court explicitly noted that this area needed keeping under review, having regard particularly to scientific and societal developments. There was a clear signal, even back then, that the standard wasn't set in stone and could evolve.
A few years later, in Causey v. the United Kingdom, 1990, the court reached pretty similar conclusions.
It did. The court again found no violation of Articles 8 or 12, largely sticking to the reasoning in Rees. It stressed again that the UK had a wide margin of appreciation because there still wasn't a clear consensus among member states on how to legally recognize gender reassignment.
Then came a case against France, BV France, in 1992. That marked a bit of a shift.
Repeat that case, BV France. Yes, this was significant because it was the first time the court found a violation of Article 8 in relation to the legal recognition of a transsexual person.
What was the key difference from the UK cases that allowed the court to find a violation this time?
It really came down to the difference in the national legal systems. The applicant was a male-to-female transsexual wanting her civil status register amended. Now, unlike the UK's birth register, seen as historical, the French civil status system was designed to reflect a person's current status and could be updated. The court found that the ongoing discrepancy between the applicant's legal status, still male on paper, and her social reality living as a female caused her significant daily problems, creating a daily situation which was not compatible with the respect due to her private life. This factual distinction allowed the court to find a violation in BV France without directly overturning Rees and Causey.
Okay, so a subtle shift, distinguishing based on the legal system. The slow evolution continued with X, Y, and Z, the United Kingdom, in 1997.
Yes. This case was slightly different. It involved a female-to-male transsexual X living with a woman, Y, who had a child, Z, through donor insemination. They argued that the lack of legal recognition of X as Z's father violated their family life under Article 8. The court ultimately found no violation of Article 8 in terms of registering X as the father, mainly because X was still legally female on his own birth certificate, creating an anomaly. But crucially, the court made a very important acknowledgement. It explicitly recognized the existence of de facto family life between X, Y, and Z. It said X has acted as Z's father in every respect. This showed the court was adapting to recognize diverse family forms created by modern life.
These cases, even the ones where the applicants lost, they really seem to show the court grappling with changing social norms, don't they?
Absolutely. And this is where that margin of appreciation concept is so central to understanding the progression. Repeat this key concept. In those early UK cases, Rees, Causey, XYZ, and the next one, Sheffield Court gave the UK a wide margin because there was no clear consensus or shared approach among Council of Europe states on legally recognizing transsexuals. The thinking was that national authorities were better placed to judge these complex social issues where views differed widely.
But the margin of appreciation isn't fixed. It can shrink over time.
Exactly. As attitudes change, as legal approaches evolve in a significant number of other member states, the margin of appreciation given to a state that's lagging behind starts to narrow. Repeat this key concept.
Yeah.
The balancing exercise under Article 8.2, weighing individual rights against state interests, evolves as societal attitudes and consensus develop across Europe. And when that happens, the state needs a much more compelling reason to justify sticking to a restrictive approach that's out of line with the emerging European standard.
And that narrowing margin seemed evident in the next UK case, Sheffield and Horsham v. the United Kingdom in 1998.
It did. The court in Sheffield, again, found no violation of Articles 8, 12, or 14, still technically following Rees and Causey. But, and this is crucial, it explicitly noted that transsexualism continues to raise complex scientific, legal, moral, and social issues in respect of which there is no generally shared approach among the contracting states. Repeat this crucial point. It basically said the lack of a shared approach was why states still had a wide margin. But just like in Rees, it again nudged the states, reaffirming that the area needed permanent review by the contracting states given the increased social acceptance and increased recognition of the problems.
So the court was clearly signaling, we see things are changing, you need to keep looking at this, even if it wasn't quite ready to find a violation based on the consensus at that specific moment.
Precisely. It was paving the way, setting the stage for a potential major shift. And that decisive shift finally came in Christine Goodwin v. the United Kingdom in 2002.
Repeat that key case, a real landmark judgment. Christine Goodwin v. the United Kingdom, 2002. And this was a Grand Chamber decision, right? Giving it extra weight.
Yes, Grand Chamber. And in Goodwin, the court took a fundamentally different approach. It found a violation of Article 8. Why? Because it said there was now a clear and continuing international trend towards increased social acceptance and legal recognition of post-operative transsexual individuals among the member states. The consensus had finally crystallized. The margin of appreciation for the UK on this issue had effectively evaporated.
So how did that change the balancing test under Article 8?
The court stated the balance had now tilted decisively. It found no significant factors of public interest to weigh against the interest of this individual applicant. The notion of fair balance inherent in the convention now tilts decisively in favor of the applicant. The state simply no longer had a good enough reason, in the court's view, to deny legal recognition.
And what about Article 12, the right to marry? Did that change too?
Yes, it did. The court also found a violation of Article 12. It explicitly departed from its earlier reasoning in Rees and Causey, stating it was not persuaded that it could still be assumed that the terms of Article 12 must refer to a determination of gender by purely biological criteria. It found no justification for barring the transsexual from enjoying the right to marry under any circumstances.
Wow. So after nearly 2 decades of finding no violation, relying on state discretion, the margin of appreciation, because there wasn't a clear European consensus.
The court finally found violations because that consensus had emerged, societal attitudes had shifted, and state practices across Europe had evolved. Repeat this key concept in case series. The Christine Goodwin decision and that whole journey through Rees Causey BXYZ Sheffield Goodwin is just such a powerful, clear illustration of the living instrument concept in action. It perfectly shows how the court's interpretation, and specifically how it applies the margin of appreciation, evolves over time to reflect changing norms and values across the member states.
It shows the system can adapt, even if it sometimes takes quite a while.
Yes, and it also highlights that the court is often, perhaps necessarily, reactive. Those changes in state practice and societal attitudes across Europe are often the prerequisite for the court feeling justified in shifting its own standards and reducing the margin of appreciation for states that are out of step with the developing trend.
And the practical result of the Goodwin case in the UK, did the law change?
It did. Following that judgment, the UK Parliament passed the Gender Recognition Act, which created a legal mechanism for individuals to obtain gender recognition certificates, formally recognizing their acquired gender and addressing the core legal problem that had been the subject of all those complaints for so many years.
That whole series of cases really brings that living instrument idea to life in a very concrete way.
It's one of the clearest and most compelling examples of how the convention manages to stay relevant decades after it was written by adapting to profound social change.
Okay, let's try and bring all these threads together now. Can we quickly summarize the key components of this whole European system for protecting human rights that we've explored today?
Sure. So at the very heart of it all is the European Convention on Human Rights, the ECHR. Its Section I lays out that catalog of core civil and political rights. Let's repeat those key rights again. Article 2, Article 3, no torture. Article 4, no slavery. Article 5, liberty. Article 6, fair trial. Article 7, no punishment without law. Article 8, private family life. Article 9, religion, conscience. Article 10, expression. Article 11, assembly, association, plus Article 13, effective remedy. And Article 14, non-discrimination in relation to other rights.
And Section 2 of the ECHR sets up the machinery.
Yes, repeat this. Section 2 creates the European Court of Human Rights, the ECTHR, defining its structure, the crucial independence of its judges, and its jurisdiction, what it has power over.
And the court's key powers.
Repeat the court's authorities. It gives authoritative rulings on interpreting the convention and protocols. It can hear interstate complaints, state versus state. And most famously, it handles individual applications from anyone claiming to be a victim of a violation by a state party, provided they meet those admissibility criteria like exhausting domestic remedies and not suffering a significant disadvantage.
And the court can help broker friendly settlements, and if it finds a violation, it can award just satisfaction, usually money. And its final judgments are legally binding on the states involved.
Exactly. It's a powerful judicial mechanism focused primarily on ensuring states comply with those core civil and political rights standards.
But the European system isn't just the ECHR and its court. It's more complex, multi-layered.
Oh, absolutely. You've got the Council of Europe as the overarching human rights organization. It's also responsible for the European Social Charter, which covers economic and social rights, using its different reporting and collective complaints mechanisms, though, as we discussed, facing more challenges in terms of enforcement compared to the ETHR's court system.
And then you have the European Union, which is separate from the Council of Europe, but playing an increasing role in human rights too.
Yes, the EU primarily, that economic and political union governed by its own treaties like the TEU and TFEU, repeat those key treaties, has increasingly incorporated human rights, most notably through the EU Charter of Fundamental Rights, repeat that key concept, which is binding on EU institutions and member states when they act under EU law. And the EU also has its own distinct mechanisms, like that political process under Article 7 TEU, repeat that key article, to address breaches of its core values, ultimately overseen by its own court, the Court of Justice of the European Union, the CJEU. Repeat that key institution, and remember, it's distinct from the ECTHR.
And we really stress that the ECHR treaties from the Council of Europe and the EU treaties are separate sources of law, even though the EU has committed to eventually joining the ECHR, which would clarify their relationship and cement the ECHR as a minimum standard for EU law itself.
It's definitely a complex picture, a constantly evolving system with different institutions, different enforcement methods, reflecting its unique history and the huge range of rights it's trying to protect across a very diverse continent.
So this whole deep dive was really designed to help you outline those historical roots of both the ECHR and the EU's human rights dimensions, identify some basic EU rights, understand the unique nature and mechanisms of the European Social Charter, summarize those key ECHR provisions and how the court interprets them, explain how the ECTHR actually operates, and just grasp the overall specific layered nature of this European system.
Yeah, and hopefully revisiting those key concepts like the ECHR, the ECTHR, the CJEU, the ESC, Protocol 11, Article 3, Article 8, Living Instrument, Margin Appreciation, and those key cases like Ireland v. UK, Engel, Handyside, Costa v. ENEL, Factor Tame, and that whole Rees to Goodwin series, hopefully touching on those repeatedly, has helped consolidate your understanding, particularly for those of you getting ready for exams.
So where does all this leave the European system today? We've definitely seen its incredible historical importance. The ECHR and its court were truly groundbreaking in making states accountable to individuals internationally. We've seen how the living instrument idea gives it flexibility to adapt, even if it's sometimes slow.
But we've also seen the very real and significant pressures it's under now. That massive caseload overwhelming the court. The huge challenge of applying the system effectively across a much larger, more diverse group of member states than originally envisaged. The rise of political forces in some member states that seem, well, less committed to core human rights values. The inherent difficulties in strongly enforcing economic rights through the ESC system, and that ongoing tension within the EU about balancing its fundamental economic freedoms against individual rights.
All of which kind of leads us to a final thought, maybe a provocative question, inspired by the source material itself, which prompts reflection on whether the European system really is the gold standard for everyone else.
Right. Given all those stresses facing the European Court of Human Rights right now, given the complexities and sometimes awkward coexistence of the EU and Council of Europe systems, and given the fundamental political challenges in actually enforcing international human rights standards against powerful sovereign states.
Can we still confidently say the European system is the unquestionable, universally applicable standard for all other regional human rights systems around the world?
Or perhaps do its current struggles, its constant need for reform, actually highlight the inherent, maybe unavoidable difficulties that any regional system is likely to face when trying to protect rights across a diverse political landscape, especially when it comes head-to-head with the entrenched power and interests of sovereign states.
It's definitely a question worth thinking about, isn't it? Reflecting on the dynamism, the challenges, the ongoing evolution of trying to protect human rights, not just in Europe, but really as a global endeavor.
We certainly encourage you to keep exploring this really vital area.
Well, that's all the time we have for this deep dive. We really hope it's been valuable for you.
And yes, to all the students listening, we wish you the very, very best of luck with your upcoming exams.
Absolutely. Good luck. Thanks so much for joining us.
Join us next time for another deep dive.